So this pretrial hearing for Rittenhouse, I'll just cover it in summary here and share with you a couple of tidbits that I found particularly interesting. This pretrial evidentiary hearing covered mostly the use of force experts that the parties want to bring into this case. Now, the defense has a use of force expert, Dr. John Black, out of Portland. Sorry, I should say Oregon. I'm not sure it's Portland. I think it's the Portland area, but certainly out of Oregon. And the state has its own use of force expert to contest that of the defense, of course, a Mr. Willis out of, I believe he's out of West Virginia. A key point here, however, is that the prosecution does not want any use of force expert witnesses to testify in this trial. The position of the state is that the events that need to be evaluated by the finder of fact, by the jury, the state believes are well within the province of normal common knowledge that a jury is presumed to possess. There's no technical or scientific facts that need to be understood for which an expert witness would be appropriate or necessary, and therefore the state opposes the defense bringing in a use of force expert witness, in this particular case, this Dr. John Black. And in this hearing that just occurred, the judge was supposed to be arriving at a decision as to whether or not he would allow this use of force expert witnesses at all, and then, of course, to do what's called a Daubert hearing, but an assessment of whether the particular experts being offered by each side have sufficient background expertise, merit to themselves as individuals be admitted as experts before the trial. But the first key issue is, well, do we need use of force experts at all? And the judge in a prior evidentiary hearing had been very skeptical that these use of force experts would be at all useful in this case. He's very much changed his tune. He received the expert report from the defense expert witness, Dr. Black, and the judge has since announced in court that he's been in courts for some 50 years, first as a prosecutor and then as a judge. And there were things in Dr. Black's report, Judge Schroeder says, the judge in the Rittenhouse case, that he's never considered before. So he sees a lot of merit now that he's seen this expert report, a lot of merit to having a use of force expert in the case. Now, I'm not going to go into detail on the Dr. Black's arguments here or the defense arguments for why his testimony would be important. I'll do that in the detailed coverage we have. Sorry, folks. We have for our law self-defense members, but I do want to mention a couple of incidents that occurred during the hearing that, as an attorney, I found interesting. One was this whole point of this hearing was to determine, one, whether use of force experts would be allowed at all, and second, if the particular experts being offered, one by the defense, one by the state, were individually of sufficient merit for their expert opinion to be admissible as evidence. And the defense showed up with their expert witness, John Black, and they had already submitted to the court and to the state Dr. Black's expert report on this case. And in the first 10 minutes of this hearing, Judge Schroeder basically opens the hearing by noting that he got the defense expert witness report, and he fully expected to have received the defense expert witness report, was wondering where it was, and had just discovered the day before the hearing that, in fact, there was no state expert witness report. It had never been submitted. Indeed, it had never been written. It was still apparently in process. Folks, this was a humiliation for the assistant district attorney in this case, ADA Binger. This is his expert. This is his report that the court was supposed to have in hand in order to make this assessment. And he looked like a schoolboy who was making excuses to his teacher about why he hadn't arrived in class with his final report that was due that day, or really had been due weeks earlier. He had no good explanation for why he wasn't prepared for this. He told the court that, don't worry, Your Honor, this report from our expert will be ready on October 18th. October 18th, folks, is less than 2 weeks before the trial is supposed to start. So one, it's pointless for this hearing because it's obviously not available for the hearing. And second, it doesn't provide the defense with an appropriate opportunity to review and challenge that expert's report only 2 weeks before the trial. Maybe when they see the state's expert's report, the defense would realize, well, we need to address or counter some of these issues. We need to do our own additional work. There's no time for that. 13 days before the trial is supposed to occur. So that is really egregious. And the judge was clearly very unhappy about this state of affairs. And it occurred to me, frankly, that this might have been deliberate on the part of the prosecution. Now, I'm speculating here. I haven't obviously spoken to the prosecution. They certainly wouldn't speak to me. But it's such an egregious oversight by the prosecution to not have their ducks in a row on this when there's a specific hearing scheduled for this, that I wonder if they just found themselves in essentially an impossible position. So remember, the state's position is no use of force experts are needed for this trial. What's going to be covered in terms of the facts is well within the province of the common knowledge of a reasonable jury. We're going to have a reasonable jury. We don't need use of force experts. Well, if that's your position, the mere bringing in of your own expert undercuts that position, right? Because the only reason you're bringing in your own expert is because you think he's going to add value for the jury. But if you don't think an expert could add value for the jury, which is your position, then you don't need an expert at all. So the very act of bringing in your own expert undermines your original argument before the court. So it becomes this circular disaster for the prosecution on this particular point. And the prosecution looked very, if you want to see a judge glaring at a prosecutor in court, almost mocking the prosecutor to his face, watch the first 10 minutes of this hearing video, which we'll make available to our members certainly over at the Law Self Defense website. Folks, I'm very hesitant to share a lot of these videos over YouTube or Facebook. They are available in different places for public purposes, but for some reason, when I embed these videos in my own content, Facebook and YouTube get very upset with me. And I'm not willing to constrain the reach of our content, the accessibility of our content for that purpose. So moving forward, you'll see very limited video embedded in the versions of our content we make available on Facebook and YouTube. We will, of course, make all that video we have available on our membership site because there's no such constraints there. We can publish anything we want. It's our own servers and so forth. But on Facebook and YouTube, you'll find it very limited. And I know other people do it. Guys like John Correa do it. That's his whole business model. And he does a good job with most of that work. I don't know how it works for him, but for us, we find we have a lot of difficulties when we embed that stuff in our open access content on these social media platforms. So that was one point, the first 10 minutes at which the prosecutor was really embarrassed in front of Judge Schroeder in this case. And then it happened again, another unbelievable act of embarrassment for the prosecutor. The defense had brought in their expert virtually over Zoom or some equivalent platform to testify in court about what he intended to testify about at trial to get the court to admit his expert testimony into court. Remember, this is a pretrial hearing, so the defense is having their expert appear before the judge so the judge can see what evidence is to be proposed and make a determination of whether that evidence will be allowed to be seen by the jury. That's what's happening in this hearing. And so the defense expert is there, Dr. Black. He spoke for about an hour at length about his testimony. By the way, the testimony is basically stepping through the video of the various attacks on John Rittenhouse. And as any of you who have seen the video, and I assume you've all seen it, it can hardly be characterized as anything but obvious acts of self-defense. I mean, Rittenhouse is repeatedly attacked, even as he's fleeing towards the police line. He's attacked by multiple aggressors with deadly force. It's hard to see this as anything other than lawful self-defense. It'll be interesting. I haven't yet reviewed the last hour of this hearing, which is when the state is essentially cross-examining the expert witness in this hearing. So it'll be very interesting to see what the state has to say about Dr. Black. And of course, they're going to present their own witness, this Mr. Willis as well. So we'll see what happens there. It seems unlikely they can really attack Dr. Black's expert opinion on the merits because the merits are backed up by the video. So I imagine they'll attack Dr. Black on some other ancillary factors, like whether his expertise is not really in law enforcement use of force and not really civilian use of force, that kind of thing. We'll have to see what happens there. But after Dr. Black had spoken, the court, that was about an hour. So the court took a break, which is very common. And then it turns out that ADA Binger was actually not prepared to continue the hearing because he'd scheduled other things for the rest of his day. Frankly, unimportant things, initial appearances in other cases, which are not very important hearings, folks, are not things that can't be moved around. They're not deal breakers on any case. It's just an initial appearance. It's a relatively unimportant proceeding. And Judge Schroeder was obviously shocked that ADA Binger had begun this hearing and wouldn't be unable to complete the hearing because he had other things to do. Other, not very important things to do. Things that, by the way, any other prosecutor in the office could have handled. There's no reason that ADA Binger personally has to be at any particular initial appearance hearing. And it's not like he's the only prosecutor in the office. The most junior prosecutor in that office could handle an initial appearance hearing. Anybody. So again, the judge just looked at ADA Binger with incredulity that this was happening, that he was not going to be able to finish this evidentiary hearing in his courtroom today because the prosecutor decided he had better things to do. It was now, of course, once he started feeling the heat from the judge, the prosecutor immediately backpedaled and said, well, I guess I can find someone else to handle those initial hearings. But again, it was such an odd thing to have happen. It just doesn't normally happen this way in a court of law. And again, it was a very embarrassing situation for the prosecutor. So I don't know if that's a portent of things to come and how the prosecutor will be managing this case. For his sake, I hope not. For Kyle Rittenhouse's sake, it can only be helpful in terms of how Judge Schroeder is going to conduct himself in this trial. He's clearly very unimpressed at this point, or at least on this day in this hearing, with what ADA Binger is bringing to the table in terms of his performance as an attorney in the case. So I thought both those events were interesting. The failure of the prosecution to have their expert report available to the court in time for this hearing, which is, by the way, these expert reports, folks, were supposed to be made available back in August. And this is October, first week of October. So another reason it was really inexcusable not to have this report ready now, well before this hearing, much less not until weeks after the hearing. But also this notion that the prosecutor had other things to do, Your Honor. I'm not going to be available for the rest of this hearing. So sorry, I have to go to these really unimportant meetings that anybody else in my office could handle. It was very bizarre from this attorney's perspective to see that happening. All right, so that's the Kyle Rittenhouse case. Again, we'll have more detailed coverage on that for our Law of Self-Defense members.